Hi, welcome back to my channel. Today's presentation is about personal data protection and about the general data protection regulation in the EU. The presentation is part of a playlist on open science, and previously we had very interesting presentation on open science, open data, so I hope you watched those presentations previously. Well, the objective of today's presentation is to learn about personal data and how to handle it, and number two is to learn about the GDPR of the European Union and to how to comply with its requirements in research. The content of today's presentation will be mainly based on some definitions, data protection, what it is, what are the individual personal data, what to do with photos and online exchanges, how to store the data, and for sure how to comply with the GDPR requirements before having some takeaway message. So let's start with definition. Well, personal data means any information related to an identifiable natural person, data subject in this case. Identifiable is a person that can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that person. And you need to take into consideration here, we are not talking also only here about personals or individuals or names. It can be a face, it can be a car number plate, it can be an address, and so on and so on. So the GDPR, or the General Data Protection, it's a set of regulations protecting the privacy of humans, and it addresses the collection, processing, storage, transfer of personal data inside and outside the European Union. It is looking at informing subjects of the use of their data, ask for consent and allowing to withdraw this consent at any time. And it looks at protecting the data from transferring, leaking, publishing, and it looks at data anonymization or pseudo-anonymization as part of this process. Now there is a legal protection and legal protection aspects. I previously talked about ethical concerns in a previous lecture if you are interested, but in general when we talk about legal protection for personal data, it's not only the GDPR in the European Union, but we can find examples also in the Declaration of Helsinki, which is talking about the rules for human experimentation. We can find in the United States the Institute of Health, the NIH for example, also the FDA in the United States. And simply you have always to contact your valorization officers at your university or at your research center or institution or even at your company for any legal professional advice to determine the data ownership during the project's life cycle. And I invite you to ask your contact valorization officer if you are going to invite people to your institution and you need to store some data regarding people who register, for example, in any event. Can you save these data on the servers? Can you save these data on your computers even after the event is finished? All these important legal aspects are very important to be taken into consideration. Now let's talk about the data protection. What is the data protection? In general, we need to have a data protection officer in any large institution where is data handling and processing happening. So a data protection officer ensures that an organization applies the laws protecting individuals' personal data. And the designation or the position and the task of the DPO or the data protection officers within an organization are described in the Article 37, 38 and 39 of the EU General Data Protection Regulation if you wish to refer to them. A very important aspect when we talk about data and personal data treatment or processing or sharing, we always need to take into account that according to the FAIR principles, which is a very commonly protocol that is used for data sharing, it's looking at making it findable, accessible, interoperable, and reusable and open access as possible. We can see that one of their conditions that they ask that personal data must be closed as necessary. So here comes the importance of anonymization or pseudo-anonymization. Personal data in research is a very sensitive matter, and the General Data Protection Regulation, the GDPR, looks at different aspects that need to be respected. First of all, we need to look at processing for scientific research purposes shall be subject to appropriate safeguards. So this is the basic rule. those safeguards, like the DPO or the data protection officers, those safeguards shall ensure that technical and organizational measures are in place to ensure data minimization, because actually this is the best practice. If you minimize data from the beginning, you have less to protect it, you have less to encrypt it, you have less to take care of it. And for sure, those measures include pseudonymization without identification of the data subject. So it's very important to take this into account. And when we talk about pseudonymization, it means replacing any information which could be used to identify an individual with a pseudonym. So this is the aspect that we should be looking at. Now, when we look at anonymization versus pseudonymization, they are not the same. You can see that I can have on the left side a personal data. Here I have Heinz Schmidt has a gamma GT value of, and then I have pseudo-anonymize the data, the same data. I can have patient 392B has the same data. And if I do only anonymization, I say a patient has this value. So between anonymization and pseudonymization, we always recommend the pseudonymization so that we give a number for this patient and then we can use it easy later on. And for sure, the key for this pseudonymization must be not possibly available for anybody. Now, when we talk about personal data processing and I'm collecting data, what should I do also? Well, I need to have a transparent process. It has to be lawful, it has to be fair, and I need to make sure that the collected data is done for specific and explicit and legitimate purposes and not further processing in a manner that is incompatible with those purposes. And this is very crucial and very difficult to digest by many people. Actually, if you are collecting data for a specific purpose, you cannot reuse the same data for another purpose. And here this makes the equation or the game rules very challenging, because I'm not talking here about general data that can be reproduced or fused or data mined. No, I'm talking here about personal data. Personal data cannot be reused for other purposes than it was collected for. So further processing for scientific research purposes shall not be considered to be incompatible with the initial purpose. And this is so important, and many people violate this rule. So you need to be aware about it and you need to take it into consideration. Data minimization is very important in this sense, and the accuracy of the data, the storage limitation, the integrity and the confidentiality and accountability of the data makes a big part of this equation. So these are the very important rules that must be respected when you are processing personal data. According to the GDPR, processing, we can say that processing means any operation or set of operation which is performed on personal data or on set of personal data. Analyzing personal data is a form of processing personal data. It involves collecting, recording, organization, restructuring, storage, adaptation, alteration, retrieval, consultation, use, disclosure, mining, and fusion. So those all the different acts that can be associated with data, and when we talk about data processing, it covers all these actions. Now let's move to a third aspect that is important here about personal data and how can we treat it, how should we collect them. Well, when we talk about personal data, according to the Rizal, Sebastian and Elena Shokanova, we can see in the TNO in the Netherlands, we can see that there's different types of personal information that the GDPR is protecting. First of all, we are protecting the IP address. Even the IP must be protected. The location, the sexual orientation, religious beliefs, date of birth, ID numbers, online identifiers, emails, phone numbers, addresses, names, photos, even if you have a picture of the car, even if you have a picture of the face. All these information associated with a person needs to be protected. So it's very important to look at that. And when we talk about personal data, what should we do as scientists who are working with individuals as subjects? We need first of all to inform them. So the person that will be used as an object or subject, in the data processing process need to be informed. they must be informed before the data is gathered, and consent must be freely given rather than implied. So this is the first rule. The second rule when I'm involving an individual, access. Individuals request access to their personal data, and they can ask how their data is used by the entity after it has been gathered. They have this right. So they can access, and they can even ask what happens with the data. Subjects or individuals, they have information corrected. They have the right that this information is corrected. So you must have protocols involving them in your data collection protocol or method or approach so that you can allow them to correct the information. Individuals have the right to be forgotten. What does it mean? It does mean that they can withdraw their consent from an entity to use their personal data. And if you are collecting data manually and they decide to be forgotten, this means that their personal data will go to the shredder, and this is very important. Individuals, they have the right of data portability, meaning that they have the right to transfer their data from one entity, one service, from one provider, from a research center to another. Imagine you are volunteering for some, as an individual, you are volunteering for some kind of testing in an institution, and you have a record of testing. You were taking a medication, or you had a certain intervention, medical intervention. If you move from a city to another, you have the right to ask the hospital. If you're continuing to do the same voluntary work or participation in a similar study, you have the right to ask for moving your data from an institution to another. If you're working in a company, and here you are out of context of academia, and you have a data of your smartphone with a provider, you want to move it to another provider, this is your right. So the Personal Data Act protects you and allows you to have this data portable to another institution. And for sure, individuals have the right that the person who collects the data restrict the processing. What does this mean? Data is not used for processing, meaning the record can remain in place but not be used. Collected for specified, explicit and legitimate purposes, and not further processed in any manner that is incompatible with those purposes. Further processing for scientific research purposes shall not be considered to be incompatible with the initial purposes. So even if you are in a scientific context, you cannot reuse the data in another purpose, especially if it's a personal data. So here by that, the individuals are fully protected, and the data cannot be sold, and the data cannot be transferred to a third party. And therefore the GDPR is very powerful in protecting personal data, and therefore it's a guarantee that once you say that you are respecting the GDPR, or you are obliged to respect the GDPR, by default, this also will make sure that people who participate in your experiments or in your service or in your whatever kind of data collection process you are doing, they are confident that they have assurance that the data will not be used. Following up after number 6, number 7, the object. This includes they have the right to object, meaning that they have the right to stop processing of the data and allow it to go to the direct marketing. So at any time they can unsubscribe from a mailing list, they can unsubscribe from the experiment, they can withdraw their information from a company, from the service, from an institution. And for sure, they have the right to be notified within maximum 72 hours if there is any data breach. Imagine there is a leak, your server is hacked, your data is out. You must inform all those people who are giving your personal data that there is a breach. Whether this breach is digitally, electronically, through a cyber attack, or if you are storing your data in a physical place, in a storage or in a cupboard that is secured and closed, and somebody breached in, there's a burglary or somebody who get access to the data, whether the data is in a physical format or digital format, if there is any breach, security breach, the individuals who their data has been exposed, they must be informed within maximum 72 hours of notification. So these are the basic rules, the 7 or 8 rules that needs to be taken into account. Now, as part of the GDPR, what should we do with photos and online exchanges? Another sensitive topic. A photo with images of people is protected as personal data, and it needs to be legally, there should be a legal basis for processing this picture. The right to use photos depend on its content and purpose of use. So if the content includes work by third parties, for example, still images from a video, then this third-party content is copyright protected. You cannot use it. The use by a research organization for text and data mining and data fusion should be based on a legal basis. So the research design should be from the beginning designed to process this data, those images, and data mining, data fusion should be included in the purposing at the beginning of the collection phase. Now, GDPR policy regarding images also requires to blur the faces of anybody who isn't subject matter unless we obtain their consent to share their likeness. So anybody who is taking pictures or the research is involving picture in public spaces, involving people, any human being appearing on the picture, if they do not have a written consent in a digital format or a physical format that their image can be shared or they can be part of your study, then you must blur these images. The same applies for cars. If you are taking pictures in a public domain and there is car numbers and there is an identification number, GDPR policy requires to blur the car plates of the car unless we obtain the consent of the car owners and share their likeness. So it's very important to take these into consideration. If we are attending online meeting, for example, no pictures can be taken without consent in any online exchange. No recording of any online exchange without consent can be done. So it's very important that we are protecting the personal data of people. If you are organizing an event, you have a seminar, you have a workshop, you have an event, you have a cocktail, whatever, and there are people invited to attend it, and during this event you are going to take pictures, or during this event you are going to do some video shoots, or you are going to record the whole event, whether in a physical format or into an online format, you always advise you always to have a permanent holder at the entry of the door of the event, and preferably also you send an email to participants beforehand and you inform them. For example, you tell them pictures will be taken during this meeting. By entering this room, you are consenting to be photographed, for example. The same can apply here. You can see the meeting is being recorded. By continuing to be in the meeting, you are consenting to be recorded. By that, you can just fix those information on a permanent paper at the entry without having a conflict with violating the GDPR requirements, and by that everybody knows that they will be filmed, they will be photographed, and this can be used for marketing, put on the website. But it's very important to not sell this information to a third party or make it available on other websites. Now let's move to one of the final parts of today's presentation, which is the data storage. What should I do with data storage? How should I store the personal data? Most of the time we are storing data on clouds. You can see we have servers and we are storing it. We put it on data repository. We can have it sometimes an external storage like laptops or hard drives. We can put it on institutional servers. But in general, if you have any physical storage, you must respect the security rules, sustainability rules, organization rules, and documentation rules. And I had a previous presentation about how to store and back up your data. If you are interested, you can watch it. And here it's very important to take this into account, especially if you are moving from a digital data storage system to a physical data storage system. Don't forget that also security. Sometimes GDPR rule requires that the servers are based in the European Union or based in EU member states in general. So this means that you need to take into account, if you are storing anything on a cloud, what are the GDPR requirements regarding the location of my server. It's not just out of the blue. Sometimes the location or the server has to be a public server provided by the state. Sometimes for sensitive, you are working with the Department of Defense, for example. So these are all examples of the importance of the storage of personal data so that third party cannot access. How long should I store my data? All data collected on citizens must be stored in the EU. So as I told you previously, the server must be in the EU and if it's physically, then it has to be in the EU. There are no rules in the GDPR on the storage limitation. However, organization must document and justify why it has set the time frame for storage. So before collecting the data, already the data protection officer need to have a framework, and the framework should say we will store it 3 years, 5 years, 10 years, but there should be a justification, a reason why it will stay 10 years, why it will stay 3 years. And what we try to do, best practice from the beginning, to minimize data from the beginning and not store it. Maximum you store it for 2 months, and by default you delete it, so that you are not getting in this problem. Now, most research institutions, if you are storing data sets, for example, you have a data set, they require to retain the data for minimum 3 to 10 years. So I invite you to ask your data management officer or DPO, data protection officer at your institution, because maybe your university or your research center or whatever your company, they have different policies. But in general, in academia, it would be requested to retain any data set generated or created during a research between 3 to 10 years in a safe, secure, and sustainable way for purposes of reproducibility, verification, and potential reuse. And again, if you are interested to know about reproducibility, you can watch the video above that helps you with that. Now, this storage is so important that some people would say that here is a conflict of interest, because in the research, we want to have as long as possible storage to make sure that we can reproduce the data and that we have a real integrity of the work in case we need to refer to it. In most cases, like I told you, it would be vary between 3 to 10 years. You have to keep the data stored. It can be in this case stored in a repository, for example. And therefore, if you already publish your data, if you make it available on an open repository as a data set, then already you don't have a problem with GDPR, especially after you pseudonymize it, then you don't have a problem. Now, last part of the presentation, compliance. This is very important. Like I told you, there will be a DPO, data protection officer, in most big institutions that work with data. Those people will have the right to inspect, and they have to communicate with the outward, and if there is any data breach, they have to be informed. And they are here not only as a police, internal police, but they are also mainly to make sure that you are informed. So they have a big role. Maybe more the informing part is more important than the policing part. But in general, you need to think about compliance. Privacy should be something done by design, and you need to be compliant in any cases. So this must be taken into account when you are working with any personal data. By default, privacy must be respected and you must comply. Map your my advice to you is to map your project's data, map where all of these personal data comes from, and document what do you want with this data. Determine what data you need to keep. Why exactly are we archiving this data? Instead of just erasing it, why not deleting it? I strongly advise you to delete as much as possible. There's no reason to keep this data. And why are we saving this data? Put security measures in place. You have to take it mega seriously, very seriously, security. Whether you are security by making sure it is on internal service of your servers of your institution, so the chance that the breach is very little, or you put them physically, if you collect them through paper, for example, in a room with a key and in a locker with a key. So you need to have at least 2 keys before arriving to the data. The data should not be left in an archive in the underground available for anybody to go through it. So very important to look at that. Review your documentation. So always check the GDPR requirement. Individuals have to explicitly consent to the acquisition and processing of their data. So pre-checked boxes and implied consent will not be acceptable anymore. And this makes it very difficult that if you are going to store it in a rigid way, and then people may be asked to retain or withdraw their consent, or they want to modify the information. If you are making it so difficult already to store it, it will be very difficult to change it. So therefore, we always recommend to minimize the data as much as possible. As a follow-up, establish procedures for handling the personal data. Establish policies and procedures to how will you handle the situations if there is a data breach. What is your plan? You need to have some scenarios. How can individuals give consent in a legal manner, for example? What will be my process? What is the process if an individual wants his data to be or her data to be deleted? What I'm going to do? How will you ensure that it is done across all platforms and it is really deleted? I don't want to have a trace in another server or another copy or a clone in another server. This is your responsibility. How will you confirm that the person who requested to have this data transferred is the person he says he is, or the person she says she is? Very critical one. You get a phone call, hi, I am this person, I work with you, can you please transfer my data to X? Okay, but how do you know that this person who's calling is the person who has the data stored or collected for? Another big problem with security and verification. That you have to ask yourself, what is the communication plan in case of data breach? What are you going to do if there is a fire, if the server is burned, if there's a cyber attack, if somebody by mistake made a connection with internet? What are you going to do? The firewall is not working, and so on. So you cannot react responsively on these questions. These questions need to be beforehand, preventively taken into consideration, and your whole data collection process, data processing process, data storage process should take those into account, and therefore we say privacy by design. By that, I end up today's presentation, and here are some takeaway messages to not forget. We are talking here about how to handle personal data, and the GDPR helps you to establish procedures for handling personal data. Use the GDPR to build up a legal basis for your work. You can only use the personal data for a predefined purpose based on a consent. Take into account that the GDPR is about informing and protecting subjects inside the EU and outside the EU. So even if it's an EU-funded project in Singapore, people there must respect the requirement of GDPR in the EU. So always perform a risk analysis, go through my checklist that I was explaining earlier, and ask these questions with your team, and make sure that you assign a data protection officers. Integrity and confidentiality is very important here, and therefore you need to always think that security will require investment, and the pseudonymization is another act that needs to be done to process this data and not leave it in its raw format. Number 4, accountability. You need to make sure that individuals can request any modification at any time, any transfer at any time, being forgotten at any time, and also you need to have a counter-attack plan for any data breach, reaction in maximum 72 hours, and a action plan, what to do if I have a data breach in a physical or a digital format, especially with cyber attacks. And finally, you have to minimize as much as possible the data. If you are using it, use it for a specific purpose and get rid of it, pseudo-anonymize it and publish it, and then you are done with it if you are a scientist. Otherwise, you have to keep it long. So in this sense, you are taking the risk. But my advice is always to save the minimum and only the useful data. This is the end of today's presentation. I hope you enjoyed it. Well, this is part of a playlist on open access publishing. I hope you watch previous videos, next videos. Don't hesitate to share the video. Don't hesitate to comment. And if you have any questions or complimentary comments, I'm open, and I'm always looking to learn also from you. So I hope you enjoyed it. I hope you can apply it in your research. This presentation was about personal data protection with the general data protection rules in the European Union. Thank you very much for your attention.